Conception would have been somewhere around May of 21. Does that sound
Yes.
about right?
We were actually in a relationship living with each other at the time.
He's voluntarily unemployed or underemployed. He testified at the referee hearing that he was working at Wing City and only making and doing like part-time employment to the extent to only pay for his child support obligation.
I went to refinance my home and save my home, so I called her and asked her if she would please sign off on the deed because we hadn't done it yet, and she told me no.
It's very frustrating from my point of view because he currently has a bench warrant out for child support.
Attorney Reed for the plaintiff. The defendant is not here.
Okay. This matter is before the court for evidentiary hearing on the plaintiff's motion to set aside referee order in this matter. I've read through all the pleadings in this particular case. I'll kind of tell you what my thoughts are, Ms. Reed, and then I'll let you proceed if you have some, I guess, dispute with that.
Right.
Okay. Court notes that the order provided if the father educates himself as to how to care for Dantel Jr.'s asthma and hearing condition, then beginning 10/15/24, father will have unsupervised parenting time on alternate weekends, Friday to Sunday at 6, in addition to the Wednesday. What the court was going to order in this matter, based upon my reading of all the pleadings in this case, is first that I think you would ask for, and I think the court believes that that's appropriate, is that the defendant would in fact have appointments set up and meet with, I think both doctors, because I think the asthma and the hearing are separate. Is that correct?
That's correct, and Your Honor already made that determination at the motion hearing, and we submitted an order under 7-day, and that was entered 9/23. And so in that order, the court addressed the communication app, defendant meeting with the child's doctors before commencing unsupervised parenting time. His supervised parenting time is going to continue, and then today is primarily about the child support issue and his ability to work.
Okay, thank you, because in the paperwork I had, I didn't see that order, so I don't know if it didn't get processed fast enough or in the file or whatever. What is your, I guess, your desire as to the imputation in this particular case?
We're looking for a minimum of at least $15 an hour. This defendant does have an ability to work. He has a history of working with the factories. He's voluntarily unemployed or underemployed. He testified at the referee hearing that he was working at Wing City and only making and doing like part-time employment to the extent to only pay for his child support obligation. And that's why the referee ordered the child support amount as is. And I don't think that's appropriate, as it was only part-time to cover that child support obligation. I understand he has pending charges at the time or right now, and he has a upcoming preliminary exam, and I don't know where that's going, but right now he is on bond. He has an ability to work. We have no information about any sort of mental or physical impairments or any sort of obligations that prevent him from working. So we are requesting that he be imputed at 15.
Okay, court will note that it's now 1:47 p.m. and it was set for 1:30. The defendant has not appeared in this matter, nor has the defendant filed anything in this matter which would dispute or contest his ability to work in this matter. So the court oftentimes does impute income of $15 per hour because of most of the factories and other businesses will pay that in this locale. So the court does believe that that is an appropriate amount to impute, which the court will do, and impute that to him as he is voluntarily underemployed in this matter. As stated, the court did note the record showed that he did testify that he's working, I think it was at Wing Street is what you've said, and that he in fact was there sufficient amount of time to get money to pay the support obligation, but that doesn't assist in making a, I guess you'd say, a reasonable determination as to what the support should be, only as to what it is. And so the court will allow you, Ms. Reed, to impute the income at $15 per hour at full-time employment, and Therefore, you can recalculate the support based upon that, submit a uniform child support order in this matter, and the court will enter that. You can submit under 7 day.
Thank you.
Anything else?
I do not believe so.
Okay, thank you. You're free to go. Have a good afternoon.
So, Ms. Egan is the mother of the child Mariana Lint, is that correct?
Yep.
And when was that child born, do you know?
I don't recall off the top of my head.
Okay. Did you sign an affidavit of parentage indicating that you were the father of that child?
I did, but only because I was unaware of exactly what I was signing. I should have asked more questions, but I didn't.
Okay. And you brought this motion to revoke the affidavit of parentage and disestablish you as the father, is that correct?
Yes.
Okay. Would it be correct that the child was born sometime in February of 2022? Does that sound right?
Yep.
Okay. So conception probably would have been sometime around early May of 2021. Does that sound right?
I believe so.
Okay. Were you having sexual relations with Ms. Egan at that time?
I can't recall exactly, but I don't think so.
You don't know when the last time when that stopped, would that be correct?
Yeah, it was. I can't remember exactly when it was,
Okay.
being honest.
And you understand that if this motion is granted, you'll have no rights or responsibilities as to that child?
Yes, sir.
Thank you. I have nothing further.
Okay, thank you.
Now, you are Mariana's mother, is that correct?
Yes.
And what is her birthday?
February 3rd of 2022.
Okay, so conception would have been somewhere around May of 21. Does that sound
Yes.
about right? Okay. And were you and Mr. Lint having sexual relations at that time?
Yes, we were actually in a relationship living with each other at the time.
Okay. And you eventually separated?
Yes.
Okay.
We've been
And-
separated for 2 years, a
Okay.
little over 2 years.
And you and he did sign an affidavit of parentage around that time, is that correct?
Yes.
When did you sign? Did you sign that at the hospital or a
Yes.
little later on? Okay.
We signed it at the hospital on the day I left the hospital, which would have been like February 5th, February 6th.
Okay. And Mr. Lint brought his motion and you and he and the child participated in genetic testing, is that correct?
Yes,
Have you received a copy of that result?
as far as I know.
Okay. You've seen it?
Yes.
Okay. And it indicates a 0% probability of
Mhm.
paternity? Is that correct?
Yes.
Okay. Do you know who the father is of the child?
I have somebody in mind that I am working with right now, but I am waiting to hear back.
Okay. Do you know that person's name?
Yes.
Who is that?
His name is Devontae Jackson.
Grants Mr. Lint's motion, would you be willing to cooperate with our office in establishing paternity in this
Yes.
case?
Yes, I will.
Thank you. I have nothing further.
Ms. Egan, just to clarify, you said that the affidavit of parentage was signed, you felt time you left the hospital, but if the records show that it was signed on February 3rd, 2022, would you dispute that?
I signed mine as soon as I signed all the paperwork. So I don't remember exactly what day I signed mine, but I know he came up the day I was leaving the hospital to sign his paperwork.
Okay. Well, I'll tell you just so the records show it was on February 3rd, 2022, so.
Okay.
I don't know if your testimony may vary from that, but it shows if he signed it at a different date, he put the wrong date on. I don't know.
I actually have a copy of it, so I can look. It says that we signed it February 4th.
Okay,
I have it right here in writing.
then the petition in this matter is incorrect because that states it's on the 3rd, so. But never mind, that obviously we've got the date on that. I have nothing further than anything else. Well, let's just address that, Mr. Magnuson. You do have the DNA Diagnostic Center report in this matter. Do you wish to move for that mission at this time?
I would, Your Honor. Thank you.
Okay. Mr. Lint and Ms. Egan, do you have any problem or objection to the court accepting the DNA Diagnostic Center report dated April 2nd, 2024?
No.
Okay. Mr. Lint?
No.
Okay. Court will admit the DNA Diagnostic Center report signed by Deputy L. Kumar, PhD, Lab Director of the DNA Diagnostic Center, showing a probability of paternity of 0%. Anything else, Mr. Magnuson?
No, Your Honor.
Okay. Court has heard the testimony in this matter, and obviously the testimony from all the parties of that the defendant signed the acknowledgement of paternity, believing that he in fact was the father of Mariana Elizabeth Lint. That in fact, it turns out there was some question at some point, and again, the parties submitted to DNA testing, which, as I stated, came out with a probability of paternity of 0%. So based upon that, the court will find that in fact, Mariana Elizabeth Lint is in fact a child born as out of wedlock and not issue of this marriage, and will be excluded, and the defendant will be determined not to be the biological father of Mariana, and will enter an order consistent with that. Ms. Egan, if you wish to get that order, you can probably get it anytime after tomorrow or tomorrow on, because I will sign it, but I've got a number of hearings after this that I have to conclude before I can get to that.
Okay.
So this is an FOC case, so Attorney Madison has to prepare that order. We don't have the generic one in file.
Oh, we don't have it.
No.
Yeah, I was going to ask that question, if the court had their own order ready,
No.
or if I needed to prepare something.
We'll need you to prepare that, Mr. Magnuson. We usually, when a party files, usually they have, it's in the file, and it's not that I'm aware of.
Yeah, we don't for sure. Yes. Because this case was reopened at FOC's motion, and so we'll let them prepare.
Oh,
the order.
okay.
Yes.
Oh, that's right. I remember
Right.
going back through this, it was dismissed, and then we reinstated the case.
Yeah,
That's
this case,
fine.
yeah, there's a bit of a difficult procedural history here, so I'd be happy to prep that.
Okay, thank you. If you would submit it under 7-day, we'll be able to get that entered and get that concluded. So, ma'am, it'll take a little bit over a week now to get that done then.
That is okay, sir.
Okay? Thank you both. You're free to go. Have a good day.
Thank you.
Court will note the appearance of Mr. Fernandez on behalf of the plaintiff, Ms. Podolsky on behalf of defendant. This motion is before the court on the defendant's motion for evidentiary hearing. Ms. Podolsky.
Well, as the court is aware, this case has been ongoing for several years. Over this past summer in 2023, there were various motions regarding counseling and the like. In September of 2023, an order entered directing the parties to participate in counseling with Margaret Hunter. That counseling was to include both co-parenting counseling and reunification counseling between father and the minor child. As outlined in our motion, Ms. Hunter met with both the parties individually. She met with the minor child individually. However, no co-parenting counseling took place. Ms. Hunter made several recommendations that included the co-parenting counseling to begin, for father to participate in activities with the minor child, attend her events, extracurriculars, contact her on Christmas, birthday, initiate consistent communication with her, and avoid any forced relationship with her. Ms. Hunter stated that these behaviors would allow the minor child to begin to heal from the trauma and possibly allow trust to develop between father and daughter. To date, the father has had no contact with the minor child. He is not heeding the recommendations of Ms. Hunter. We are past now the Christmas holiday. There has been no contact. There's been no participation in any of her events, and he refuses to participate in the co-parenting counseling, which is not just recommended through her report, but it is included in that court order. That was a stipulation to attend counseling with Ms. Hunter, if this court remembers that meeting where that was discussed. So at this point, Your Honor, we have seen zero progress. We believe it is time to schedule the evidentiary hearing on custody, and we're asking the court to get that scheduled. That is stemming from defendant's second motion to modify the judgment of divorce regarding custody, child support, parenting time, and other relief.
Okay, thank you. Mr.
Thank you.
Fernandez?
Yes, Your Honor, thank you. We are not opposing setting an evidentiary date. Our client would just like it if we could set a later date if possible. We think there's a good chance of resolution, but Tara still isn't really in a place to handle those negotiations at the moment. But he does believe it may resolve, and yes.
Okay. Well, what we'll do is we will set it for an evidentiary hearing, and we will contact both your offices and try to arrange a date. So, okay. Anything
Your
else,
Honor.
Mr. Podolsky?
Nothing, thank you.
Mr. Fernandez?
No, Your Honor, thank you.
Okay, thank you both. Court will end this matter at 9:03 a.m. You're free to go. Have a good day.
Thank you.
This matter is before the court on the defendant's motion to enforce judgment of divorce. The plaintiff has stated in the motion that Mr. Herter, that you refuse to sign a quitclaim deed for the property so that she can refinance. Is that accurate?
No, sir, that is exactly opposite.
Okay. Tell me then, why has a deed not been signed?
The deed hadn't been signed because I didn't know that that I had to have her taken off the deed. I knew she was not on the mortgage, but I didn't know that she was still on the deed.
Okay.
And I went to refinance my home and save my home. So I called her and asked her if she would please sign off on the deed because we hadn't done it yet. And I was told she told me no.
Okay. Says Ms. Schultz. Ms. Schultz, why has the deed not been signed?
Your Honor, I have no problem signing the deed. I've actually already talked to the title office. I will not do it in person with him, but I have no problem going to the title office and signing off. It's very frustrating from my point of view because he currently has a bench warrant out for child support. I'm also being sued for one of the bills that he was supposed to pay in the divorce paperwork.
Okay, well, that may be, ma'am, but it requires that the deed be signed. You need to sign it. All that other stuff you can address by a motion yourself if you have an issue with any of that. But it shouldn't hold up this, and you've talked to the title office. So when will you be able to get in and get that signed?
I let them know that I can sign that this week. I also had questions because in the divorce paperwork, it said that he was supposed to do that within 6 months.
Okay.
And it's been almost 3 years.
Okay. Well, regardless, it's now time is going to be done. So what I'll do is I'll order that the ma'am, that you would sign that within a week. So you'd have 7 days from today's date to sign that.
Right.
And you can get that taken care of with the title office, and that will conclude this matter. If in fact there are other issues, then you can bring those back on a motion. Okay. Anything
All right.
else? Sir?
Thank you, Your Honor. I appreciate that. And I recently went to Calhoun County and paid my warrant off. So I do not have a warrant. It just probably has not gone through the system.
That's fine. That's not before us today. Ms. Schultz, anything else you have?
Nope, that's it. Thank you.
Okay. Thank you both. You're free to go. We'll close this matter at 9:06 a.m. This is the time and place set for the evidentiary hearing on the determination if a child is born out of wedlock. In this matter, first, Ms. Daniel, tell me, I don't have the date of birth of the child.
He was born June 6th, 24.
Okay. And so that would put the date of conception probably in sometime September, October of last year, 2023. Is that correct?
Yes, September. My last menstrual was September 4th.
And tell me, as it relates to Mr. Daniel, when was the last time prior to that you'd engaged in sexual relations with him?
It's been years. I left him 2022 on Thanksgiving.
Okay. So clearly he's in no way could he possibly
No,
be the
there's
father.
no way. Definitely.
you state that Mr. Searles is in fact he's the alleged father in this matter. Has he engaged in any relationship with the child since the child's born?
Yes. Oh, yes.
Has he accepted responsibility as the biological father?
Yes. He pays for daycare, everything. We live together.
Oh, okay.
Yes.
Okay, thank you. You've heard the testimony of the plaintiff in this matter. Is that testimony appear accurate to you?
Yes.
Oh. Okay, that's all I need from you, sir. It's just to confirm what she had stated. Anything else, Ms. Daniel, before we conclude?
Do you need to talk to the biological father? He's with me if you need to talk to him about anything.
Yeah, why don't we have him come in and I'll have him sworn as well.
Okay. Give me 1 second. I will get him.
Okay, thank you.
Yes. Thank you.
Mr. Searles, I'm going to take some Searles in this matter. Miss Daniels has testified. Go ahead, you can put your hand down, have a seat. Ms. Daniels has testified and stated that you are in fact the biological father of Jamar Marcel Searles. Is that correct?
Yes.
And that is actually your name as well, correct?
Yes.
Okay. And the child was born in June of this year. And she has stated that you are residing together, you are paying in all the expenses of the child. Is that correct?
Yes.
And you understand, if you acknowledge and state that you are in fact the biological father of this child, you accept those financial obligations and responsibilities.
Yes.
Are you willing to do so?
Yes.
Okay. And at the time that the child was conceived in approximately September or early October of 2023, were you in fact engaged in sexual relations with Miss Daniel?
Yes.
And in your mind, is there any doubt that you are in fact the biological father of Jamar Marcel Searles?
Yes, he is my son.
Okay. Thank you, sir. That's all I need from you then.
Thank
You're
you.
free to go.
Okay.
Sorry
Okay.
about that.
No, that's fine. The court will make the following finding. The court's heard the testimony in this matter. The testimony of the plaintiff is that, in fact, she had not engaged in sexual relations with the defendant since sometime back in 2022. That was confirmed by the defendant as well. And we have Mr. Searles, who is the biological father, who came in and acknowledged that he is the biological father. And there was no doubt in his mind that he was engaged in sexual relations with the plaintiff at the time of conception, that he has been responsible for and paying for the expenses of the child, and he agrees to accept those responsibilities as well. As a result, the court will find and make a finding that Jamar Marcel Searles is in fact a child born out of wedlock, not issue of this marriage, and as a result, the court will enter the order in this particular matter. That will conclude the case. You're free to go. And Ms. Daniel, if at some point you want to get the order, you can probably get it after today's date. It may take a while to get in and processed with the clerk's office, but after today, you should be able to get that.
Okay.
Okay?
Yep. Thank
I
you.
do have a question.
Sure. Go ahead.
Now, does that mean that we can get the birth certificate for him now? Because they
Yes,
withhold it from us?
once you have this order, then they're going to require that you get a certified copy, and then you'll have to file the forms to send that up to the state of Michigan.
Okay.
Okay?
Thank you.
Okay, thank you.
Thank
Have
you.
a good day.
You too.
The kids catching me and my so-called girlfriend, because I do not have a girlfriend, having intercourse, we're polyamorous. It was all three of us, and the kids walked in on all three of us. So I can't deny that. The kids, they unfortunately walk in on all three of us having intercourse.